Namaskar, Satyameva Jayate. In front of you today I will discuss about the relationship between law and forensic science. With the help of my college or institution, that is IFS, International Forensic Science Department, I'll be quoting from this book, and I will be quoting the relationship which is very much evidentiary and formulated, structured by IFS, none other than IFS. So here we start about the critical points in the interaction between law, policy and forensic science. Okay, there can be a question that what is the relation, ma'am? People ask me, ma'am, tell me the relationship about between forensic science and law. It's a very basic question as well. So with the emergence of threshold studies, it is also not only periodic but it is customary these days. Yeah, so we have to give the proper rectifying answer. When I say rectifying answer, I mean there should be corrections. Yeah, okay. So I don't want to go wrong. That's why I am reading out thoroughly from the book. The most basic interaction of law and policy with forensic science is that of defining what the law, the legal system and the legal actors expect from forensic practitioners. This involves policy choices within the legal system. When legislators create law such as one allowing for the commitment of violent sexual person, lawmakers are making a policy decision about how to handle person who suffers from mental abnormality, what professionals may be involved in that legal process, and what specific role forensic practitioners must and may play. Such policy decisions are also at other points in the legal system. For example, the federal and the state judiciaries, which are responsible for developing, approving, and implementing the rules of evidence in their respective jurisdiction, are responsible for deciding what evidentiary standards and threshold will have to be met for a psychologist to be permitted to provide expert testimony in a case. We will return later in this chapter to a detailed consideration of the implication of the particular rules chosen for the admissibility of preferred forensic testimony. So, what can be, again question can be arises like, what is the assigned role of a forensic expert? Being a forensic expert, what role shall I or we perform? Perhaps the most important and the basic policy the law has made regarding use of forensic psychologists in a court cases is to allow them to serve current and prospective litigants or court in 4 roles. Number 1, as a consultant. Sometimes I do consult. Yes, I do. On prior, call, I do consult. Expert witness providing adjudicative testimony. Number 3, expert witness providing educational testimony. Number 4, expert witness providing legislative testimony. Understanding these roles is critical because the assigned role can affect the validity and or appropriateness of the forensic service. Understanding policy is critical because it affects the ability of forensic psychologists to provide their services and circumscribe the way in which those services can be utilized. Ironically, research on psychologists' abilities to influence policy and the best means to create such influence is still in its infancy. In a consulting role, the forensic practitioners are asked in inform clients or how specific psychological knowledge, experience, and information that may be beneficial to the client's interaction within the legal system. For example, a forensic practitioner is a consulting role to an attorney. Might be asked by the client how to select a jury favorable to their case, or what question the attorney may want to ask the opposing psychological expert during depositions or trial. Legal policies have allowed for the use of psychologists as jury consultant who can sit at the attorney's table in the courtroom, provide questions for the attorney to ask prospective juries, or for other insight for the attorney to use, accept, or reject prospective juries. But such policy can change or have changed in some courts with an attorney's right to question our juries, and hence effectively use jury consultant being severely limited or eliminated. In contrast, forensic experts retained to offer adjudicative testimony will focus their attention on providing expert testimony concerning a specific individual or fact to aid the jury or the judge when the jury is empaneled. For example, such testimony might focus on the defendant's mental state at the time of the crime. Yes, he can take a defense on this, that, my lord, my client is unsoundness of mind. He is suffering from mental illness or traumatized. That's why he performed this crime. He can take this ground. The defensive counsel. If a testimony is, it is discovered whether the defendant is competent to stand trial or the most appropriate custody. Arrangement in a contested child custody proceedings. The role of expert providing adjudicative testimony is likely the one with which forensic practitioners are most familiar, and it will serve as a main focus of the rest of the chapter. In such a role, the court will be judging the admissibility of the proffered testimony, which places preparatory obligation on the expert that differed from the imposed consulting expert. Legal policy in this role and in the next two roles focuses on whether or under what standards will forensic psychologists be allowed to present such testimony. As noted earlier, we will consider the legal policies in gender detail later in this chapter. Forensic practitioners also provide educational testimony to court. Such testimony is typically offered to educate the jury, or they can improve their decision making on a particular issue in the trial. Right? Now, it has also been barred somewhere, and there are limitation has been set. Finally, forensic expert asked to provide legislative testimony in the court cases are typically being requested to address the social fact that will influence whether a particular law is constitutional or not. For example, the United States Supreme Court in Brown versus Board of Education 1954, it is a case law, was asked to determine whether separate public education was unequal for the races and violated in the US Constitution. The court turned to psychological expert to provide testimony about the impact that educational segregation had on children. In the case of Kenneth Clark, a social psychologist offered expert testimony detailed the harmful effect of segregation based on studies he performed on segregated and desegregated elementary school. If the expert provides legislative testimony, the use of mnemonic signs based on the group data would be appropriate to answer the court's question, while the provision of adjudicative testimony based on mnemonic data without ideographic information based on the individual data would be more likely to rule inadmissible. Thus, the role of forensic expert in assigned affects the forensic services being requested and the approach and information that the expert should offer to fulfill their role obligation. Other legal and policy issues and lessons here are very similar to those discussed under adjudicative testimony and will not be repeated. So again, there are many legal questions, but till now, so far, I'm done with this chapter about the relationship of law and forensic science. So let me know if you have any question or doubt in terms of this chapter. I have just made and prepared a lesson for you all. So till then, have a great life ahead. Thank you so much for hearing me out. This is Cherry signing off. Thank you.